I'm from Disabled People Against Cuts, and Mark asked me to talk about Disabled People Against Cuts and about the UN Convention on Rights of Persons with Disabilities. Oddly enough, they are linked because I'd been on a training course with Rachel Hurst from Disability Awareness and Action early in 2010 on the UN CRPD. Basically so we could all learn how wonderful these rights were going to be for disabled people. And at the time I was a trustee of a disabled people's organisation. Then came George Osborne's budget in June 2010, and it was obvious to me and to a number of other people that actually something drastic and horrible was going to happen to the rights we already had. The Tory party conference was in Birmingham that year, and I live in the West Midlands, so I decided it would be a good idea to organise a disabled people's protest at that conference, and that is basically how DPAC emerged. First, the police said we couldn't possibly lead the march because we were too vulnerable. We had to get lots of international disabled people's organisations to complain to them. And obviously nowadays, for the parts of DPAC that take direct action, and not all our supporters do because not everyone can, and they contribute in lots of other ways. But obviously the police don't see us as being vulnerable anymore. We marched under the slogan of Cuts Kill. We were criticised for scaremongering, and I'd love to say, you were right, we were scaremongering, but no, I'm sorry, I think we were right. So many disabled people have been driven to suicide and to death by the cuts that this government have imposed, and we must fight back and we must stop them. We obviously know, and I'm sure that feeling is shared by disabled people's organisations, that we need a voice for disabled people that is led by disabled people, not the charities who speak for us and who are financed by government. And the problem for DPOs is they are constrained to some extent as well because they have to survive by being service delivery organisations, which is why the sort of Equallives DPO, Norfolk DPAC sort of combined strategy seems to work quite well in a number of places where you have a campaign group who can campaign without any constraints, supported very much by sort of the formal DPO. We have a number of upcoming events. We have a second court case against the closure of the Independent Living Fund on October the 22nd at 12:30 outside the Royal Courts of Justice. We're supporting the Occupy camp, which is being set up on October the 17th, and they're taking over Parliament Square. After the TUC march, which is on October the 18th, people will be marching back to Parliament Square from there as well. We have plans for next year because we have to influence political parties. We have to make sure that if we have a Labour Party elected, it is actually in some ways different from the Tory Party, and that it will actually support disabled people's human rights. So we've been doing a lot of lobbying together with Inclusion London and others, with Labour politicians, with the TUC, as well as sort of our direct actions to make our protests visible. But we still need to do a lot of work on the Labour Party. They're not saying anything that is making any of us feel reassured at all. But we're planning to have a battle bus, and we're going to take it to about 5 places around the country and in various parts of London. Again, it'll be a combination of giving legitimate information to people and having a very visible presence in the hope of pressurising politicians to take notice of disabled people. And then moving on to the UN Convention. It's basically, the UK government ratified the convention in June 2009. There's a few exceptions on the armed forces, some aspects of inclusive education and immigration. It basically commits the UK government, including the devolved administrations, to take concrete action to comply with the legal rights and obligations contained within the convention. The key point about the UN Convention is that disabled people's rights must be progressively realised. So what you have already has to be built on and not taken away. It's supposedly policed by the Equality and Human Rights Commission and Scottish and Northern Ireland Human Rights Commission, but they're not terribly proactive. They are, though, technically the people who should be monitoring the implementation of the convention. Disabled people campaigned for over 20 years to get their own human rights convention and were instrumental in agreeing its contents. Therefore, a key principle of the convention is the continued involvement and participation of disabled people and their organisations in promoting, protecting and monitoring the implementation of the convention. The UN Disability Committee monitors the implementation of the convention, and it looks at about 5 or 6 countries a year. What happens is that the government produce their reports, and in November 2011 the ODI submitted a report on how the government were implementing the convention in the UK. It was 126 pages saying how wonderful everything in the UK was for disabled people and what wonderful job the government are doing to progressively realise disabled people's human rights. After that, the EHRC and civil society groups then have the opportunity to produce a shadow report, putting forward their views and evidence. EHRC carried out a consultation earlier this year asking what people thought were the most important issues, as they planned to just cover 3 of the articles in their shadow report. The UK report, shadow report, was going to be submitted in August this year, but that date is now being postponed, we think, for about 12 months. One of the shadow reports is still being produced by the Reclaiming Our Futures Alliance, which includes DPAC, Equallives, and over 300 other DPOs and individual disabled people. As many things are different in England and in the devolved administrations, each country was also going to submit their own report, and Disability Rights UK were going to submit their own. At least 1/3 of their funding comes from central government, so we're not sure that that would be impartial. As well as the shadow report, you get to submit a list of issues. You can pick up to 25 key issues according to the UN. The shadow report has to take a particular format, including research, individual case studies, and it can also have references to newspaper articles as evidence. It is supposed to be only about 20 pages in total, which is very restrictive when you're facing so many attacks against your human rights. Submission of the report is followed by those groups who submitted them being able to appear at a hearing of the Disability Committee in Geneva. Again, this hearing only lasts about an hour in total. As well as the UN Convention and the main articles, there are also optional protocols, which were signed up to by the UK, but not by all countries. For example, Canada and Southern Ireland haven't signed up to the optional protocols. They give an additional means of being able to challenge what's happening in the UK, and there are 2 types. One is for individuals, where no further legal action is possible in a particular country. There have been hundreds of submissions, and only 3 have been taken up by the Disability Committee so far. One involved a woman who was refused a swimming pool in her garden in Norway, and one access to cash machines. We also have one in the pipeline about the closure of the Independent Living Fund to new applicants from 2010, but at the moment we can't do anything about that until we know the outcome of the court case. There's another optional protocol that can be used by civil society groups, which can result in the UN Disability Committee initiating an inquiry into a particular country. At the moment, this process has only ever been used once, resulting in an inquiry against the UK government. The process is highly secretive and confidential, but the fact that this is happening was leaked by an ex-member of the UN Disability Committee this summer at a conference in Galway. To use this protocol, you have to prove that what is happening is not only regressive, but also a grave and systematic violation of disabled people's convention rights. The other problem with the convention is that Maria Miller said it was soft law, and since its articles aren't incorporated into UK laws, they can be ignored. So I think importantly, the articles have been included in legal challenges and are now sort of being incorporated into our legal system, which makes them stronger to use if you can get access to legal aid to mount a legal challenge in this country. Talking of legal challenges, that reminds me that we are actually wanting to mount a legal challenge against the timelines involved in claiming PIP. We have a solicitor who's willing to take the case, but we need volunteers who would be interested in challenging the time delay. So if you know anyone or come across anyone who might like more information, if you could ask Mark or put them in touch with me.